And so welcome everybody. This is session number 2 of the Legal Aid series for refugee service providers and supporters. Our presentation today focuses on custody challenges for parents and guardians without marriage licenses, whether that's a cohabiting couple or a couple whose marriage was not recorded in their home country. I'm looking forward to Hallie Martinelli's presentation. Natalie, if you could go to the next slide, just to give you an overview of the presentation. So far, we've had immigration and criminal law. That video is available on our YouTube site. If you need to get a copy of it, please let me know, and I will make sure you get that link. Coming up next, we will be getting a presentation regarding troubleshooting benefits issues for refugee households, particularly when there's a transition in the household. And finally, we will wrap up with a review of the written materials and the videos that already existed. And if there are any specific questions that you may have about how those issues affect your clients. If we could go on to the next slide. Again, for that final presentation, there are several videos and written materials that cover issues ranging from care, kinship care, relatives caring for smaller children, housing, landlord-tenant issues, domestic violence, employment law. So I would encourage you to review those materials because that final presentation will be focused on your follow-up questions for those materials. Again, you can contact me or Natalie Ziegler if you need that video. And as a reminder, if you have a referral from a refugee, if you are a refugee service provider and you have a referral of particularly a refugee with barriers to using our intake process, please, again, do email me with that referral so that I can shepherd that through the process. So again, before we get started, a little overview about legal aid. Our mission is to secure justice and resolve fundamental problems for those who are low income and vulnerable by providing high quality legal services and working for systemic solutions. We provide services in several areas, including across Northeast Ohio, Cuyahoga, Ashtabula, Geauga, Lake, and Lorain counties. We assist with the problems related to housing, money, benefits, employment, family, and more. We also represent community groups and nonprofits and low-income entrepreneurs. Generally, households with incomes below 200% of the federal poverty guidelines are eligible. Anyone in need of assistance should call our intake line, 1-888-817-3777, or please do, if you are working with a client who has a language issue or a challenge accessing our intake line, I welcome you to start an application for them online at our online intake at www.lasclev.org. We'll make sure that link gets into the chat. And make sure you note the language, and again, send me an email to let me know that you've made that referral. So without further ado, please let me welcome Hallie Martinelli. Hallie is an attorney in the legal aid family law practice group. She has been with Legal Aid for 2.5 years and has worked with our Language Equity Committee, so has some familiarity with populations speaking a non-dominant language. Welcome, Hallie. Sorry, before we go to the presentation, if you have any questions, Hallie had said she will take questions during the presentation. Either drop them in the chat, or as we're a smaller group, I would welcome you to unmute and ask your question.
Yeah, thanks, Catherine. So welcome, everyone. Like Catherine said, my name's Hallie Martinelli. I'm a senior attorney in our family practice group. So I represent folks who are victims of domestic violence and are experiencing divorce, in need of protection orders, or child custody issues. So I understand that custody is a topic that maybe you all see with some frequency in the refugee folks that you work with. So I'm going to focus on custody issues today. You can go to the next slide, please. Okay, so before we kind of dive into some of the unique issues or specific issues that might impact refugee folks, we're first going to give kind of a general overview of custody, because I don't know all of your backgrounds and levels of knowledge of this, but I think it's important to just kind of first understand the basic terms that we're going to be that are going to be coming up, and be able to distinguish some of these. And the other reason that this is important is because often, I mean, I see it all the time. Folks don't really, I mean, this goes for everybody, not specific to refugees, but a lot of people don't use custody related terms wrong. So they don't realize, if they're saying, I have custody or I want custody, throwing out words like sole custody. A lot of people will say that, but not really understand what it means. So this is, I think, an important distinction to start out with. So sole custody means pretty much exactly what it sounds like, that one parent is the sole residential parent and legal custodian. This does not have anything to do with the amount of time that each parent spends with the child, which we'll dive into a little bit more in a second. Shared parenting means that both parents are the residential parent and legal custodian, and so they share those parenting responsibilities. Again, this has nothing to do with the amount of time or the schedule of where the child resides. This is just talking about those major decision-making decisions that come up in parenting, like medical decisions, educational decisions. A shared parenting plan is when both parents are doing those things together. And whereas in sole custody, only one parent has all of that responsibility. So you can go to the next slide, please. So like I alluded to, custody does not always, and actually rarely correlates with parenting time. So parenting time is just referring to the time that the child's with a parent. This also applies to somebody who's not necessarily a biological parent, but has custody or another type of guardian role through the court. But I will kind of refer to parent a lot. I guess just keep in mind that that would also apply to another third party who's not a biological parent, but who has custody of a child. So for example, you could have a sole custody schedule, or a sole custody arrangement, meaning only one parent has custody, but the other parent still typically has parenting time. This is something in my experience that's really difficult for immigrant folks in particular to grasp because of the the vast cultural differences that surround that. Most commonly, both parents are awarded time, regardless of what the custody arrangement is. So some other terms that we'll see throughout are best interest of the children. This is a legal term of art that overarches all custody determinations. So when you're thinking of, well, how does a court even determine custody in the first place, best interest of the children is kind of the focus throughout all of the different laws that govern that. And then parenting time, like I said before, is just, it's called visitation or possession time, but in Ohio, we call it parenting time. It's just the schedule of time that the child's with each parent. And then the allocation of parental rights and responsibilities. This is the order. It's a very long way of saying the custody order. And this is the order that the court sets forth custody and parenting time. Go to the next slide, please. So in Ohio, there are a few different ways of establishing custody. And I'm actually gonna go kind of backwards from the last one on this list to the first one, because number 3 there is the most straightforward and simplest. So in Ohio, when a child is born to an unmarried mother, that mother automatically has sole custody. She doesn't need to go to court or do anything. She automatically has sole custody. And so there's no action needed there. On the other hand, for unmarried fathers, they automatically have nothing when a child is born to an unmarried couple. So the father doesn't have any parental rights or parenting time or anything like that without taking it upon themselves to go to juvenile court and establish that. And you know, unfortunately, the laws are still pretty far behind in terms of you know, keeping up with the evolving nature of a family and structure of a family, how children are conceived, you know, what a parent looks like. So the laws are, you know, pretty binary, at least right now, where we have, you know, unmarried fathers, unmarried mothers, and we don't, you know, the law doesn't really account for much else at this point, but hopefully, you know, we catch up with the evolving family structures. Then if we're talking about married folks, there are a few different ways to establish custody, and all of them kind of would happen when either the marriage is coming to an end or the parties are deciding to go their separate ways. So a divorce and a dissolution, people often use interchangeably. They are the same thing in that they result in the marriage being terminated. But a dissolution is only when the parties can agree on everything, including custody, parenting time, everything regarding the children, prior to even filing with the court. So a dissolution, everything is agreed upon and signed and then filed with the court, and you know, you say, please adopt this. And so it's a very quick process once it's filed, but it doesn't work unless, you know, the parties are able to agree on absolutely everything. Divorce is when you can't agree on absolutely everything, which is the more common route, especially really the only route that we deal with. Legal separation, you hear a lot, or at least I hear a lot from people saying that they want a legal separation, but it's actually very, very rarely used. It does everything that a divorce does: separates property, divides debt, allocates parental rights and responsibilities. The only difference is that the parties remain married at the end. So the only, for example, I've seen it used in for religious reasons. So if the party's religion prohibits divorce, they may go this route so that they're able to live separately, but they're technically still married. But like I said, that's very rarely used. You can go to the next slide, please. Okay, so then we come to the question of how is custody determined? And like we talked about a little bit before, best interest of the children really overarches everything. But specifically, the law sets forth a number of factors that the court considers. So this is a big question for people a lot is, well, how does the court figure out who should have custody and what that will look like? And so the law sets forth these factors, and I've listed them kind of shortly here. So wishes of the parents is pretty straightforward. The child's wishes if the child's interviewed. So in some circumstances, if a child is, of an appropriate age, which there's, I should mention, there's no like cutoff age. A lot of times people think that, if a child's over 12, then they can say what they want or whatever age. There isn't a cutoff age in Ohio, but obviously if it's a child who's not speaking, then this wouldn't be appropriate. Anyways, if the court determines that they need to talk to the child, then the judge can interview the child. And so if that's done, then the court also has to take into account whatever the child says during that interview and says what their wishes are. So they'll also look at the interaction with parents and siblings, anybody else who would be around the child regularly. And then they also look at the child's adjustment to their home, school, and community, which comes into play a lot when you have parents who aren't local to each other. So if you have one parent who lives in another state or another country, this is going to come into play heavily if, the child is going to school here, is adjusted to all of that. That would be a big factor. Thank you. And then the mental and physical health of all involved, the parents, the children, are there any significant health issues that are going to affect a parent, a parent's parenting ability? And then this is another big one that I deal with a lot. So the parent more likely to facilitate parenting time. This now, of course, is going to be talking about parents who are relatively close to each other. So this is talking about local families, but if a parent has historically withheld a child from the other parent, that's not going to look favorably upon them in the eyes of the court necessarily because of this factor here. Because the court has to feel comfortable saying, if I give you custody, are you going to make sure that the child goes, with the other parent when they're supposed to? And this is something that folks have a hard time with. I think potentially the number one question that I get asked is, well, if blah, 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 if X, Y, and Z happens, do I have to send the child? And most often the answer is yes. However, of course, there are exceptions to this if, there is reason to suspect or that they know of abuse that's happening or a dangerous situation where it would, be dangerous to send the child. But otherwise, withholding the child can end up hurting you in the long run. And then lastly, next, I should say, whether each parent has failed to make child support payments if there is a child support order. This does not mean that this doesn't apply to if there's not a child support order. So most people, I guess understandably so, expect the other parent to help them out financially and help, buy the child things and support them financially. This is only applying if there is an actual court order for child support, not just generally supporting the child, if that makes sense. You can go to the next slide, please. So then the next factor is a big one as well. It's whether either parent or any member of the household has been convicted of a series of offenses that all surround domestic violence and abuse. The key word there is convicted of, because as I'm sure all of you know, there are oftentimes abuse allegations or history of abuse without a conviction. I think particularly with immigrants, with refugees, the abuse may not have ever been reported, and wouldn't have been, so there wouldn't have been a criminal conviction. And so this wouldn't necessarily apply. So that abuse, that alleged abuse wouldn't be taken into consideration, which is not ideal, of course. But as you'll see, when we go on a bit, it is still factored in somewhat, but that word convicted here is a big thing to be aware of. Go to the next slide, please. And then similarly, this looks a lot like the factor that we talked about earlier, but whether a parent has denied the other parent's right to parenting time. Like I said earlier, that tends to not look favorably on that parent. And then, of course, whether either parent has established a residence outside of the state. So, of course, if there's going to be a distance in between the parents, then certain things are just not going to be practical or feasible. Go to the next slide. Okay. So then there are, in addition to all the factors that we just went through, there are additional factors that the court looks at when it's thinking, okay, I think shared parenting might be appropriate here. So how do I know if shared parenting is in the best interest of the children? So when they're making that determination, all of those prior factors that we just went through have to be considered, as well as a few additional. And those additional ones really speak to the nature of shared parenting, which is that the parents have to be able to work together. Shared parenting, they have to be able to communicate, to make decisions together, because they each have, a 50-50 role in those types of things. And so that's the first factor there. And then similarly with the second one, in order for shared parenting to work, the parents have to, you can't have parents that are discouraging the child from talking to the other parent or having a loving relationship with the other parent. Next slide, please. And so then here's where we come back to the abuse allegations. So this one is much more relaxed and does not require a conviction. It's just a history of or potential for child abuse, spousal abuse, domestic violence, or kidnapping. And so this, without a conviction, it requires more of, an argument to convince the court that it did happen. But it can still be considered even if there's no criminal conviction or no report ever. And then geographic proximity, we already talked about. And then they'll also consider the recommendation of the guardian ad litem, if there is one on the case. So a guardian ad litem is someone, usually it's an attorney, but it's not always, that's appointed to a case where there is a lot of contention regarding what the custody should be and what the parenting time should be. So the guardian isn't affiliated with either side, they're neutral, and they represent the best interests of the children. So they will do an investigation, they'll talk to the children, they'll talk to the parents, they'll go to the parents' homes, anybody else who might be relevant, like teachers or doctors, siblings, and they will advise the court on what they believe is in the best interest of the children. And this isn't always the same as what the child wants. So the guardian doesn't represent the child, they represent the best interest of the children, which sometimes are not the same. And when that happens, then generally the child would need their own attorney in addition, because the guardian feels that their best interest is not what they want. You can go to the next slide. So then these are just some other custody tools that are sometimes used in addition to a guardian ad litem. Mediation, if the parties are able to communicate and there's no power imbalance there. Family evaluation services is what we call it here in Cuyahoga County. Different courts have different names for it though, but it's the same idea. They have folks who will complete a much more limited investigation than a guardian and issue a recommendation. And then, you know, when you have unique issues regarding custody, sometimes expert witnesses are helpful. You can go to the next slide. Okay, so then that was kind of our broad overview of custody, kind of our run through custody in a very short amount of time, but hopefully that at least laid kind of a base foundation when we start to talk about some issues that are more unique to refugees. So my understanding is that something that's seen by you folks often is people who are caring for children and they don't have a marriage certificate. So, and I see this a lot too with folks who are married in other countries. They often don't have any official record of the marriage. And so that becomes a question then of how to go about ending the marriage through a divorce or one of the other methods that we looked at earlier. So if a couple was married, went through a ceremony or did whatever, you know, they did to recognize their marriage and whatever in their home country, if they move then to the United States and try and file a divorce, there's no requirement to submit a marriage certificate or any record of a marriage. And that goes for anyone filing a divorce. You don't have to include proof of that marriage. The court just presumes that that's true, that you're married. So when this would really come into play is if someone without a marriage certificate files a divorce and the other spouse then comes in and says, wait, no, we were never married. That was all just a fun little show. We were never actually married. We were never, legally married. That's really when this would come into play, is if the other spouse is challenging that. Otherwise, you could proceed with a divorce just as anybody else could, because there's no need to kind of prove that the marriage that you're asking to be terminated exists. So you can go to the next slide, please. So then let's say, you have the other spouse that does come in and say, wait, we were never married. This marriage wasn't valid. The question then becomes, how does the court determine if that marriage was valid? And so the Ohio Supreme Court has held that that determination is focused on, you look at where the parties were married and what was valid there. So if the marriage was valid where it was solemnized, it's valid here. It's valid everywhere else. If it was invalid there, it's invalid everywhere. So for example, the Supreme Court case that kind of came up with this standard involved two first cousins who had gotten married in Massachusetts a long time ago, but at that time, Massachusetts prohibited first cousins from getting married. Ohio did not. And so they got married in Massachusetts, moved to Ohio, and then one filed for divorce, and it was challenged. And the court said, well, since when they married in Massachusetts didn't allow first cousins to get married, their marriage was invalid, and therefore it's invalid here in Ohio too. So Ohio can't divorce this couple because there was no marriage to begin with. That's just one example. You can go to the next slide, please. So then the next question is the marriage valid in the country where it was solemnized? And that's not always as straightforward as it might seem. So the Ohio has also held that a religious ceremony in and of itself is not necessarily enough to establish that a marriage was valid. The couple must have followed all of the procedures that are required of the country and region where they're married. So, for example, this case here dealt with a couple who was married in South Korea, and they had a ceremony. Neither party, disputed that there was a ceremony. I think there were pictures from the ceremony. They, lived as though they were married. But one of the spouses then later tried to challenge that when they were here in Ohio. And it turns out that South Korea had a variety of kind of administrative stuff that you had to go through in order to register your marriage. So like different paperwork that needed to be completed or filed or whatever their process was. The couple didn't do all of that. So they had the ceremony, they did, whatever was signified marriage under their religion, but they did not comply with the laws of South Korea. And so their marriage was determined to be invalid. You can go to the next slide, please. Okay. So if the marriage is found invalid, then you can't pursue the divorce route. And so a divorce automatically determines custody as well. And so if the court says the marriage was invalid, the question becomes, well, how do we parent the children? How is custody established if we can't get a divorce? So at that point, the couple would be treated as any other couple who's unmarried, because that determination that the marriage wasn't valid means that that they were, in the court's eyes, never married. So unmarried parents have to go to, here in Ohio, have to go to what's called juvenile court and establish custody. And then that determination is made considering all those factors that we looked at earlier. You can go to the next slide, please. Okay, so then in talking about interstate and international custody issues, the big law that governs this, excuse me, is called the Uniform Child Custody Jurisdiction and Enforcement Act, which is a mouthful, so we call it the UCCJEA, which is also kind of a mouthful, but that addresses interstate child custody orders and issues. And every state has codified their version of the UCCJEA, and I put the citation for Ohio's UCCJEA there for you. We can go to the next slide, please. So the UCCJEA a term that kind of is present really throughout it and is very important when you're considering it is this phrase called the home state. And the home state is the state where a child has lived with a parent or a person acting as a parent for at least 6 consecutive months right before the commencement of the custody proceeding. And then, of course, if the child isn't 6 months old yet, then it's where the child has lived from birth. So even it's not necessarily where a child was born, and often isn't where a child was born. It's where the child has lived for the last 6 months. Go to the next slide, please. And also important to note when we're talking about the UCCJEA, Ohio treats a foreign country as if it were the same as another state in the US. So an order from a Michigan custody order is the same as, treated the same under this law as a custody order from Brazil, let's say. Go to the next slide, please. So the UCCJEA kind of tells us who can do what and how to go about it when there are folks living in different places or folks have previously lived in different places. For example, if the parents live in different states or different countries, if the child is in a different state, the UCCJEA is what sets all of that forth that we'll go through. So starting with how do we know if Ohio can make an initial custody order? So an initial custody order is assuming that there are no other orders that exist regarding this child or children. So no other orders exist. Now somebody needs to establish custody. Does Ohio have the authority to do that? And the answer is going to be yes if one of these applies. So if Ohio is the home state of the child, so the child has lived here with a parent or person acting as a parent for the last 6 months, then you're good to go. Ohio can make that order. If Ohio was the home state of the child within 6 months, but the child currently is not in Ohio. So for example, I think that this is confusing, at least for me, to read without putting it in some context. So for example, if mom, dad, and child lived in Ohio for 10 years, and then mom and child moved to Tennessee, and father stays in Ohio. And after 2 months after they leave, father files with the court. Ohio, under the factor number 1, isn't going to be the home state of the child because the child no longer lives there. But they will qualify under number 2 because within 6 months, so since it's only been 2 months since they moved in this hypothetical scenario, the child did live in Ohio and the child is now absent from the state since him and mom has moved to Tennessee. But a parent still lives in the state. So that's father who stayed behind, who's still in Ohio. So in that scenario, Ohio would still have the ability to make an order regarding that child, even though the child's now in Tennessee. And again, when I'm using other state, this applies loosely to other countries as well, we noted before. You can go ahead and go to the next slide, please. And so then the last way that Ohio can make an order is if the home state, so if the home state is not Ohio, but the home state has said, you know what, Ohio, we don't want it, you can have it. And then both of the following A and B here have to be true. there has to be some significant connection with Ohio, which is more than just physical presence. It can be, somebody attends school, works in Ohio, pays support, owns property, a variety of different things, but it has to be more than just a presence in Ohio. And then also that there's substantial evidence available in Ohio. So this comes into play when, another court may be the home state, but the child, is now going to school in Ohio, in counseling in Ohio, all their doctors are in Ohio. So anybody that would be potentially have relevant information for a custody decision, anybody who's been involved with the care of the child would be relevant, and they'd all be located in a different state, which would make the court process very inconvenient. You can go to the next slide, please. So that is looking at when Ohio can establish an order if there's never been one before. There's a different set of criteria for whether Ohio can modify an order from another state or country if another order from somewhere else already exists. And so there are different factors for that. One of the following have to apply. If Ohio just says, or the other state, says that Ohio is more convenient. So that could be for the reason that we just talked about, that Ohio has all the witnesses and evidence. If Ohio or the other state determine that there's not still a parent residing in Ohio, so somebody still has to be residing here, even if the child is now somewhere else. And then you can go to the next slide, please. Okay, so then another big it's not really a law, but another big concept in international custody issues is the Hague Convention. So the Hague Convention is a treaty between about 90 different countries, and there are a variety of different documents that they may or may not have signed, but really the purpose of it is to set forth kind of how countries will cooperate with each other on a variety of different issues. But the one that's important for refugees is the Child Abduction Convention. So the countries that are a signatory to this convention have an agreement between each other to work together to ensure that if a child is removed from a country wrongfully, then the country that they're taken to will cooperate and has the authority to return that child. So this is really, really important when there's any concern or possibility that the other parent may take the child outside of the country. You want to know whether that country in question is a signatory to the Hague Convention, because if they are, while of course it would still be terrible if the child's wrongfully taken to that country, at least there is some process that is established where the other country will cooperate and has the authority to send the child back. However, if the other country is not a signatory to the Hague Convention, there's no process in place, and there's nothing that that makes them able to send the child back, or that kind of binds them to do that. So if there's a concern that another parent will take the child outside of the United States to a country that is not a signatory to the Hague Convention, It's definitely important that the court knows that and knows that the country in question is not a signatory, because that danger, there's a danger of the child being wrongfully removed in any circumstance, but that danger really intensifies if that other country is not a signatory to the Hague Convention, because it's going to be really, really difficult or potentially impossible to get the child back if they're taken to a country that didn't sign on to this treaty. So you can, I put a link there to be able to view the countries that are signatories to this. I don't know if this PowerPoint will be available, but I can maybe put it in the chat too if we want to do that. Will they be getting the PowerPoint, Catherine?
Yes, we'll make the PowerPoint available.
Okay. So the link is there if you want to look at which countries signed on to that. So then we can go to the next slide, please. The other way that the Hague Convention comes into play is when you're serving another parent. So anytime any kind of legal action is commenced, anybody else on the other side of the action has to be what we call served. And there are specific laws that say how you have to serve someone. And Ohio has their own set, which usually includes certified mail, in person via a process server, and sometimes ordinary mail, depending on the type of action and the circumstance. However, if a country is a signatory to this convention, which is the Hague Convention on the Service Abroad, it has a very, very long title that continues, but that's the first part of it is the Convention on Service Abroad. And it sets forth how the countries who sign on to that, how to serve someone who's residing in that that particular country with a legal action or a subpoena or whatever you would be serving. And so this is really important to know because Ohio has also held that even if you can show that a person who's residing in another country actually did receive the notice and the documents that were filed, because that's the whole reason that we care about service, right? So that the other side has notice that, an action has been commenced and they have notice of, a court date if applicable or the next steps. And so the court here, at least in Cuyahoga County, has held that even if you can show that all of that notice was given, that the other person who's residing in another country has, was handed a copy of everything, that's still not considered good service, and the whole case can kind of be out the window if that country signs as a signatory to the Hague Convention and the Hague procedures were not followed. So it's very particular, and I linked there also the countries that signed on to this section of the Hague Convention.
Hallie, could I ask a question at this point just about service?
Sure.
In a custody case, is it necessary to serve the other parent regardless of where they are and name them in the case? Or if it's if it's, for example, siblings taking care of a child, do they have to serve the parent if they want to seek custody?
Generally, yes. If it's, whether it's another parent or somebody that's not a parent, like a sibling, trying to obtain custody, then yes, they would still have to serve the other parent. And this brings up potentially another question of, well, what happens if we don't know where the other person is? And so there are ways still to complete service if you don't know where the other parent is, but that you have to be able to demonstrate that you've tried to ascertain where that other parent is, and that you've taken steps A, B, and C to try and do that, and they've been unsuccessful. And so you have to demonstrate that basically you've done everything that you can to find the other parent, and you just don't know. And so you're still able to complete service if that's the case, as long as those attempts are made.
Thank you.
You're welcome. You can go to the next slide. I think that was it. Yeah. So I don't, of course, know what types of issues you guys see regarding custody, but I'm, open to take any questions. There's my contact information as well. You can either unmute or put the questions in the chat.
I hope, please do ask your questions. I have one more, if no one else has any questions. I'm curious, Hallie, if you could, back to the beginning, you talked about an unmarried father going to juvenile court. What does that process look like?
So the process is if someone's going to, if someone wants to go on their own without meeting with a lawyer and establish custody. So I can really only speak for the juvenile court that I practice in, which is Cuyahoga County, but each court has their own, process. So I can, speak to how it is here. There are, folks that will assist someone in completing the paperwork that's required. So they'll have to submit an application to determine custody. And actually, I should say prior to that, before the court can look at custody, paternity has to be established. So if paternity wasn't established when the child was born, which, contrary to popular opinion, if the father is on the birth certificate, that does not establish paternity in and of itself. The father must have signed an acknowledgement of paternity, which is generally done at the hospital. But just the fact that the name is on the birth certificate does not mean that paternity was established. So that's actually the first step, is establishing paternity, and that can be done through the juvenile court as well. They'll order a DNA test and establish paternity. Once that's established, then they can file an application to determine custody. And so there are a number of different forms that are required. There's an application. There's what's called a UCCJEA affidavit, which notifies the court if there have been any other orders or cases that have happened in another jurisdiction. So they will have to fill those out. They're generally, the court will kind of give them some direction on, what needs to be filled out. And then those are filed. There's a filing fee associated, but folks can apply to have that fee waived if their income is below a certain level. And then the other parent would have, the mother would have to be served, or if it's somebody else that has custody, but generally it's the mother would have to be served. And then the court will have a hearing to kind of determine what the circumstances, what each party wants or doesn't want, And then the case kind of can take, you know, a number of different directions from there, depending on the circumstance. But that's kind of the process to get in the door, if that answers your question.
Yes, thank you. Any questions? Anyone have any questions before we wrap up? Thank you, Hallie, very much. It was an informative presentation. Looking ahead, we will be back here on March 8th for presentation with Deb Delman and Corley Drozda about benefits issues, specifically what do you do with benefits when the household is changing, and what are some common issues that refugees and immigrants face with benefits? So I look forward to seeing all of you on the 8th. We will make this presentation, we'll send out a link to the video, but it'll also be up on our YouTube site. And please go and check out the materials that are available on the registration page, on the event page for this series, so you can be prepared for the final presentation on March 22nd. Thanks, everybody. Enjoy the rest of your afternoon.
Bye, everyone.